All right, we're going to try and resume right now. Thank you, everyone. This afternoon's first panel addresses immigration and human rights and follows, I think, quite well after Elisa's remarks on refugees and some of the issues that she touched on. First, just a note on organization and the panel. You may have seen that Lisa Scott, immigration attorney, has her own quite large immigration practice in Chicago, was scheduled to be here. Unfortunately, she has taken ill and is unable to join us and does send her regrets. And unfortunately, we will be without her presence on the panel. But we are quite pleased to have three very able practitioners who will and professionals who will discuss these issues with us. To my farthest right is Professor Josh Blackman from South Texas College of Law in Houston. He specializes in constitutional law of the United States Supreme Court and the intersection of law and technology. Is author of the book Unprecedented, The Constitutional Challenge to Obamacare. Was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Has testified before the House Judiciary Committee on the constitutionality of executive action on immigration. He is an adjunct scholar at the Cato Institute, the founder and president of the Harlan Institute, and really what strikes me as far more important and really fascinating, he is the founder of Fantasy SCOTUS, which is the internet's premier Supreme Court fantasy league.
Play.
In fact, yeah, I went on the website. I mean, you can win up to, what is it, $10,000?
Big prize coming up, yeah.
Yeah. So check out that website. That's one of Professor Blackman's very important contributions. He also blogs at joshblackman.com. He clerked for the Honorable Danny Boggs on the U.S. Court of Appeals for the Sixth Circuit and the Honorable Kim Gibson on the U.S. District Court for the Western District of Pennsylvania, and is a graduate of George Mason University School of Law. We look forward to hearing his remarks. We also have with us in the middle Professor Alexander Kuick, who actually teaches here, teaches immigration law here and helps run the immigration clinic here at Case Western. He is also a partner at Robert Brown LLC, an immigration practice, where he oversees the firm's litigation practice, focusing largely on removal, deportation, defense matters, and general litigation. Well-versed as well in family-based immigration practices, which include the preparation of immigrant visas, consular processing, and naturalization and citizenship matters. He has a background in legal ethics, which is a trademark of both his practice style and is a value that is prized by his firm. Finally, we have David Leopold, who is a partner at Ulmer & Byrne here in Cleveland. He has a diverse immigration, visa, and citizenship practice, which focuses on employment and family-based immigration, the representation of employers in Form I-9 compliance matters, complex removal cases, and federal court litigation. Mr. Leopold is also the past president and past general counsel of the DC-based American Immigration Lawyers Association, the premier bar association of immigration lawyers and professors in the U.S. He is quite outspoken, and you may recognize his face from various news outlets and what have you, and writes in various publications as well on these issues. So I'm quite pleased to have these three experts in these issues. I think we're going to first hear from Josh to give us a good understanding of some of the law that courses through some of these issues of immigration and human rights.
Thank you so much. It's great to be here at Case Western. My talk today will begin on the travel ban, which I'm sure we're all familiar with. Usually, landmark cases that present foundational constitutional questions trickle up to the Supreme Court over the course of years. For example, NFIB versus Sebelius, the Obamacare case, took about 3 years to get to the court. Obergefell v. Hodges built upon decades of LGBT litigation. And during that process, advocates on both sides of the debate developed carefully crafted litigation strategies. Other types of major cases rush to the court after crises. Bush v. Gore comes to mind. Likewise, the famous Steele seizure case took less than 2 months to resolve. These latter types of cases arose out of true exigencies. The judiciary was forced to mobilize in response to an emergency, that the other branches were just unable to resolve. Trump versus Hawaii, the travel ban case, fits into neither category. The legal issues were not difficult, and the circumstances were not exigent. Without question, the president has a statutory and constitutional authority to deny entry to aliens from certain countries based on national security concerns. Yet, the judiciary moved at warp speed to halt President Trump's signature policy. Why? The travel bans denied entry to aliens from predominantly Muslim nations. And these policies, there are three versions, trace their roots to overtly anti-Muslim statements made by then-candidate Trump prior to the inauguration. Furthermore, the government could only offer the faintest patina of a rational basis to defend the policies. Confronted with these facts, the lower court uniformly enjoined the travel bans, all three iterations. Ultimately, only the Supreme Court upheld the final version in its entirety. And this all happened over the course of 18 months. The first version of the travel ban, which I'll just call Travel Ban 1.0, was signed 1 week after the inauguration. There were no exigent circumstances that justified the entry ban, and its rollout was a colossal disaster. Within hours, courts intervened to block the entry ban. Within days, the judiciary entered the first raft of nationwide injunctions against the Trump administration. Following defeats in the Courts of Appeals, the acting Solicitor General declined to petition for certiorari on Travel Ban 1.0. Instead, they withdrew that policy. Next up came Travel Ban 2.0. After it was signed in March 2017, the self-professed legal resistance replayed its playbook. Nationwide injunctions halting the policy were promptly affirmed by the Courts of Appeals. Except this time, the Supreme Court intervened. They allowed most of the policy to go into effect. The message to the lower courts was clear, at least to me. Treat this case like a normal case. Part 3, or Travel Ban 3.0, if you will, was announced in September of 2017. This policy was designed to be permanent, not interim. Once again, it was challenged in the courts. And once again, nationwide injunctions were affirmed by the Courts of Appeals. Yet, the court intervened again. In December of 2017, the Supreme Court permitted the entirety of Travel Ban 3.0 to go into effect. This interim decision was a conclusive indication that the lower courts had gone astray. As a result, there was no surprise when in June of 2018, the Supreme Court upheld the third iteration of the travel ban in its entirety. Now that the saga is drawn to a close, we can assess some questions that are raised by this case, which I'd like to discuss briefly. And these are the questions which are the subject of my essay for the Case Western journal that should come out at some point in the future. First, what happens next? The case only went to the Supreme Court on what's called a preliminary injunction, right? That's not the end of the road. Courts can proceed to what's called summary judgment, and if there are disputes of material facts, as you know in CIFPRO, a trial may be warranted. Now, what does that mean to have disputes of facts? Well, you need to know what exactly is the government doing to implement the travel ban policy. That gives rise to a plaintiff's favorite word in the English language, discovery. And they will try, as they should, it's rational, to get whatever documents they can from the Trump administration about how the travel ban is being implemented. And then one point in particular is worthwhile. Are waivers being granted? Justices Breyer and Kagan wrote a concurring opinion where they said, it was a dissenting opinion. It was a dissenting opinion. They didn't join the Sotomayor dissent, but they said that there's perhaps reason why the government may not be doing what they say they're doing, and they're not issuing waivers to people with various hardships. So I think there'll be a lot of discovery requests about how the government's fulfilling their policy. But I still think there are certain limits here. The court spoke 5-4. Justice Kennedy's gone, but I think Judge Kavanaugh will replace him very shortly. And it strikes me as very unlikely that the Supreme Court will turn around and say, just kidding, this is actually unlawful. I think it's very unlikely. But I think at a minimum, the discovery request will serve a salutary benefit and ensure the government is in fact issuing waivers according to the policy as they say they would. So there might be, I think, salutary benefits to the discovery process beyond any ultimate litigation victory. The second question is far more meta, and I think it's come up throughout the symposium. On the eve of the oral arguments, Robert Barnes, a reporter at the Washington Post, wrote a headline. The headline said this. It said, in travel ban case, Supreme Court considers the president versus this president. The president versus this president. And this is a theme that I've developed since, January 21st of 2017. Have the courts treated this president differently than the presidency in general? The Supreme Court answered this question without any equivocation. Chief Justice Roberts wrote, quote, we must consider not only the statements of a particular president, that is Donald Trump, but also the authority of the presidency itself. And I think the court set an important tone here. They wrote, the entry suspension, that is the travel ban, is an act that is well within executive authority and could have been taken by any other president. The only question in evaluating the actions, the only question is whether this particular president issued it, right? I think the court's signaling that, yes, Donald Trump disrupts all norms in all manner of our lives on a daily basis in 140 characters at a time. But the Supreme Court sent a signal that he should not be treated differently than past presidents, even if he defies all of these norms. Justice Kennedy made this point even more bluntly in his concurring opinion. He said there are cases where an official, that is the president, may have broad discretion free from judicial scrutiny. Let me say that again. That there are some officials, such as the president, who may have broad discretion free from judicial scrutiny. That when the president acts in certain spheres, it's subject to political checks, not the same sort of judicial checks. I think we will see this when the DACA litigation comes up to the Supreme Court later this year. David and I debated the DACA issue yesterday.
I won. Joking.
I think it's more of a stalemate, but I'll leave it there. The third question is, how does the Constitution apply to aliens who are already within the United States? And this is an important limitation on Trump against Hawaii. That case only concerned the government's power to deny entry to aliens. It does not affect aliens who are already here. The question of what due process rights are available to aliens within the interior, I think, is still an open question. The court didn't touch that. There's also the question of cross-border shootings. This was Hernandez versus Mesa, which came to the court a couple years ago and wasn't resolved. As another case in the Ninth Circuit, what happens when a federal official fires a gun across the U.S. border and kills a person on the other side? So I think you're going to have a resolution of that case later this year. Another question that wasn't resolved in Trump v. Hawaii but might get some attention is the scope of the president's inherent powers. Now, is that Robert Jackson right there? Is that Robert Jackson? So Robert Jackson, a great justice, wrote a but he wrote a concurring opinion in the Youngstown case. Youngstown Sheet and Tube Company versus Sawyer. And in that case, President Truman asserted an inherent power by virtue of Article 2 of the Constitution to seize the steel mill in a time of crisis. And the court rejected the argument that he had an inherent power. Jackson wrote that labels like inherent and implied have no meaning. and that we shouldn't read the president to have these sorts of authorities. Well, in a case in 1950 called U.S. ex rel. Knopf versus Shaughnessy, the Supreme Court said that the president has an inherent power to exclude aliens. Jackson dissented in that case. Knopf was also a four-member majority, so it's not a five-member court. But we still have this precedent, which says the president has this inherent power to exclude. Only Justice Thomas's concurring opinion in Trump versus Hawaii reached the scope of the inherent power question. So I think we'll have to address that at some point. The fifth and final question that I think is lingering is, what is the permissible scope of nationwide injunctions? This is a very lively issue. Long before there was President Trump, there was President Obama, and you had conservative state attorneys general seek nationwide injunctions on a fairly regular basis. DAPA, for example, was a leading one issued against the Obama administration in 2015. The court hasn't weighed in on this question, and they didn't need to in Trump against Hawaii because they found that the policy was lawful. Therefore, the injunction was void regardless of its scope. But I think at some point the court will address the scope of nationwide injunctions, and it may come up in another immigration-related context, that of sanctuary cities. That is, can the decision to withhold money from a single city, Chicago for example, warrant an injunction against the withholding of money against any city, right? Is a nationwide injunction appropriate when you have a single city losing their funding? I think that's probably the case where the court will take this issue. I'm going to stop there. I think these tease up issues about travel ban, DAPA, DACA, sanctuary cities, and gives plenty of fodder for my friends to discuss. Thank you all so much for your attention.
Thank you, John.
Thank you, everybody, for coming today. I think I'm coming from a different viewpoint. As Avi mentioned before, I teach here as well as I am in private practice. My piece that I presented is kind of an intersect of how asylum law works, judicial independence, and Attorney General Jeff Sessions kind of running amok on some viewpoints, or whether he has the authority to do what he's doing. One thing I kind of want to start with is actually has happened this past Monday. And luckily I have the quote here. On Monday, there was 44 new immigration judges were sworn in. During Mr. Sessions' statement, he says, "Good lawyers, using all of their talents and skill, work every day like water seeping through an earthen dam." That's Mr. Leopold and I, since we're in private practice. We are water sleeping through. "To get around the plain words of the INA, which is the Immigration Nationality Act, to advance their clients' interests. Theirs is not the duty to uphold the integrity of the act. This is our most serious duty." He goes on to say that many of these cases that you will see present complex legal issues, but anyone acting as a judge, we'll talk about these judges, you must manage your docket and support staff well. Cases must be moved to conclusion. My piece started with the tale of a case called Matter of ARCG, which was a BIA, which is our Board of Immigration Appeals precedent decision, affording asylum protection to victims of domestic violence in certain situations. Immigration courts, as most courts, are very slow to issue precedent. This case came out in 2014, set a framework for protection for countless victims of domestic violence, specifically in Central America. From 2014 on, we had lots of cases that were successful. We actually had one here at Case Western that they litigated in the springtime. Come early spring, there is a case that is down in Charlotte, North Carolina's immigration court, where the immigration judge refused to uphold ARCG and issue a grant of asylum, even though the court was remanded, or the decision was remanded back to the court to do so. That judge certified the case back to the appeals court, and once it got to the appeals court, Attorney General Sessions took the case, and under the authority afforded to him, he essentially rescinded a matter of ARCG, saying victims of domestic violence are no longer a particular social group for purposes of asylum. And one thing I present is whether or not this is proper or not, whether or not this was legally what we wanted to see. Kind of in this day and age of the Me Too movement and all these things are going on, we're seeing in Hollywood, the perception is, hey, domestic violence is no longer protection. This is what we're doing. And what's the message that we're sending at that point? This follows a similar case called Matter of Castro Tomb, which is out of the Philadelphia Immigration Court, where a gentleman, or I should say he was a minor at the time, came in unaccompanied, filed for asylum, was turned over, and given a host family in the Philadelphia area. He was sent hearing notices repeatedly, never showed up to court. The immigration judge up there continued the case at a few point in time, saying there's no due process here because the government cannot prove that he properly received notice. The government couldn't prove it, and the judge, this is a due process violation. I'm going to do what's called administrative closure. I'm going to close this case from an active docket to see whether or not the government can prove to us that he's gotten his due process warnings and was able to go to court. That eventually went up to the appeals court as well. The appeals court remanded it back, saying, issue one more hearing notice. He doesn't show up, order him removed in absentia. He doesn't show up. It's 12 days later, and the judge at that time closes the case again, or issues a continuance at that point, to which the government finds out about this, goes up to Jeff Sessions again, and they send a replacement judge for the next hearing. That judge who was sitting on his docket that day was removed from a single case that day. A replacement judge came in, ordered the individual removed, and that's the end of the story, right? Well, not. I mean, the first time since I've been practicing, I've been doing this for 13 years. Mr. Leopold, you've been longer, so I don't want to date you, but so let me know. But I've never seen immigration judges kind of get up in arms and file a grievance, and this is what they've done. And the judges have filed a grievance saying our independence is being essentially bashed. And these are not Article III judges, these are employees of the Department of Justice. Now they're given quotas. I think the number is 700 cases have to be completed a year. If you are an immigration judge, you're working, 230 days a year on whatever the government schedule is. You're going to finish 3 cases a day. And some of these cases take years. I have a case on October 4th. It has started in 1993. And it's now wrapping up hopefully on October 4th. So to think they're going to finish 700 cases in a year is, putting a timeline on these judges. But it's also for the judges to consider, as practitioners, are judges going to make haste and rash decisions because they're under a gun? Hey, guys, I got to get these cases done by making these decisions. But part of my whole story at the end of this is Jeff Sessions doing the right thing? And that's something we have to consider. The immigration court is backed up. Cases are going on for 3, sometimes 4 years. Are cases like Castro Tomb where an individual doesn't show up for 5 times and you keep giving him continuances? Are you just creating a further backlog? It's not for me to decide. It's not for just more further debate. But is that the fundamental issue of this? Is this actually doing the right thing in the end of the day? So that's my piece. I think you should all read it. I'll autograph it. That's it.
Thank you. Hi, I am David Leopold, and I graduated after he did.
Yeah.
So
A year.
So I called Avi the other day, and I said, what do you want me to talk about? And he said, anything you want. So I went and I started looking around and did some homework here. This is what I can talk about. I did choose one subject, but this is what's going on in the courts under this administration. These are not holdover cases. This is what the Trump administration has brought us. We've got children in detention, children who have been separated from their children, from their parents at the border, including children detention. You've got about 10 or 11 cases in federal court going on across the country. DACA. Josh mentioned DACA. 15 cases on the legality of withdrawing DACA or DACA itself. You've got cases challenging the census. You've got cases on what they call sanctuary cities. You've got cases on the travel ban, of course, and asylum, the withdrawal of temporary protected status. So, look, I'm not going to beat around the bush. We're in a total crisis right now, legally, ethically. We are in the immigration system like never before, whether it's the immigration courts, which we just heard about, which I'll talk about a little bit, whether it's the agencies that adjudicate business immigration petitions, whether it's the embassies overseas that issue visas. The system is under attack by an anti-immigrant president who is supported by anti-immigrant extremists, people like Stephen Miller, who was Jeff Sessions' protege, people who like the ombudsman over at the USCIS, the U.S. Citizenship and Immigration Services, who was the executive director of a group called FAIR, the Federation for American Immigration Reform, whose founders, funders, original board members were white supremacists and white nationalists. I'm not making this stuff up. Go to the SPC, Southern Poverty Law Center website. That group's designated a hate group. These are the people that are setting immigration policy, so let's start from that perspective. All right, Jeff Sessions, we heard that name. We hear that name a lot. And, you know, we hear him usually in the media in the context of he's this brave soul who's withstanding all this onslaught by the president on Twitter. And some of that, you know, is kind of hard to understand. But I think I understand why he's there and why he remains in that position and what the value of that position is for him. You know, when Trump was elected, people generally thought, well, Jeff Sessions is going to get the Department of Homeland Security. And then all of a sudden he became the Attorney General. And I knew exactly why he became the Attorney General. So what I did was I wrote a piece. I won't read it to you. I'll just tell you about it. I wrote a piece in which I wrote 5 ways in which Jeff Sessions can attack immigrants as Attorney General. This was published on the 5th of January before he was even before the Senate. 1, here's the 5 ways. Impose his radical anti-immigrant ideology and decisions on the federal immigration courts. Well, we'll talk about one of those. Alex just talked about one. So he's doing that. Expand the number of immigrants who are deported even though they qualify for a green card. The fact that Jeff Sessions has tinkered with an immigration judge's ability to manage his or her docket means that with quotas and with performance quotas that also have been case completion quotas that have also been imposed on the immigration courts, that people who deserve to be here because of their legal rights will be deported. People who are here doing it, playing by the rules, if you will be deported. That was number 2. That was number 3. Reduce access to counsel for those in immigration proceedings. Now understand that in immigration proceedings, there is no Sixth Amendment right to paid counsel. There's a right to a lawyer at your expense or a free lawyer, and they're supposed to advise you of that. And there have been programs. Sessions has gone out of his way, and the Trump administration in general, to deprive indigent immigrants of access to counsel. Criminalize immigrants. Criminalize immigrants by bringing up trumped, and I didn't mean this as a pun, but that's trumped up charges against ordinary workers. Well, what we've seen an increase in raids. There were a couple raids here in Ohio, and we've seen indictments on identity theft and things like that. We've also seen the mass criminalization of Central American asylum seekers through the use of the criminal courts to charge somebody with what we call, it's not, generically they call it illegal entry when you come in without a visa or permission. It's actually entry at a point other than as designated. We can talk about that later for a variety of reasons. I think that's illegal in and of itself, those charges, charging those people under what they call zero tolerance with criminal acts. This is all Sessions. And of course, strong-arm state police and local officials to become immigration agents, sanctuary cities. We've seen that. So everything that I thought he was going to do, he's done and more. All right, so let's focus a little bit on the courts. We heard that there were a group of new judges, 44 new judges this week. Well, what was Sessions really saying to these new judges who were just beginning to start? He was telling them, he was basically saying to them, I'm your boss and you follow what I say. And statutorily, he's right. The way the immigration courts are set up is the immigration courts are not a creature of statute. They are a creature of regulation. What's a creature of statute is obviously the scheme of the Department of Justice. So the Department of Justice, the Attorney General has under the law the authority to, he delegates authority to the immigration judges, or the immigration courts, I should say, or whatever he wants to call them. They've developed what's called the Executive Office for Immigration Review, and within that office they have what they call immigration judges. Now, we can dispute whether that term is appropriate because they're not getting independent review. What they're getting legally is review by an agent of the Attorney General. And the statute itself, the Immigration Nationality Act, refers to the Attorney General. So these are the law enforcement agents of the Attorney Generals who happen to sit in what we call immigration courts, legally speaking. So it's not independent review. So but what's happened? Does that mean that when an immigrant walks into court, all of a sudden they get ordered deported because they're in front of a law enforcement agent? No, actually it hasn't meant that over the years. There have been, by way of tradition, by way of enactments, by way of regulation, what these courts have developed into, what these bodies have developed into, are quasi-judicial bodies, quasi-independent. In reality, what that means on the ground, in court, is that sometimes you get a good judge and sometimes you don't. Sometimes you get a good judge who's going to listen to the hearing, going to listen to the reasoning. Sometimes you get a judge that'll just churn, but I think we can see that in other courts as well. The difference here is that you're not getting independent review, so when the first time you get before an independent judicial officer is usually on appeal. Petition for review, agency petition for review, here to the Sixth Circuit or whatever circuit you're in. By that point, you're dealing with issues of deference. You're dealing with fact-finding that is very difficult to overturn as a matter of standard. So it's not great, but has not traditionally developed as a place where people walk in to get ordered deported. It is a court of statute and regulation. So what's going on here? Well, Sessions, of all the attorney generals, at least of all the attorney generals that I've practiced under, and this is both Republican and Democrat, this is the first time that we've ever seen an attorney general really flex his power in the immigration courts in a way that basically is saying to the judges, you are my agents, you will do what I say. This example of sending in an immigration judge for one case to make a ruling is one brazen example of it, what he said to the judges. But also, he's issued opinions, and he's gone out of his way to change the way the law runs. There was mention of what was the name? Matter of no, the procedural case.
Oh, Castro-Tum.
Castro-Tum. So what's going on in that case? All right. So in immigration court, strategically, there are times when you want to go to trial right away because you have a client who has relief, meaning that he or she has a pathway to a green card or has a pathway to asylum or has some sort of a pathway to stay in this country lawfully, on a permanent basis, or leave without an order of removal. There are other cases where you need time. You're not delaying, and the courts are set up so that you're not able to delay, but I can give you a concrete example. So suppose I'm representing a woman who is married to a United States citizen. That marriage was in place before she was placed in removal proceedings, so the law says that she can apply to be designated as the spouse of a U.S. citizen by the USCIS, the U.S. Citizenship and Immigration Services. And once that works out, once they say, yes, we agree that this marriage is bona fide, you can go to court and say, hey, judge, can you give her a green card? She's not a criminal. She doesn't, she's admissible to the United States. So traditionally what's happened is the courts have said, okay, we will continue this matter. It's called a matter of Garcia de continuance. We will continue this matter until the USCIS makes its decision. That's reasonable because she's got a clear pathway to citizenship. Once the USCIS makes that decision, come back to me, we'll recalendar the case, and I will decide. Doesn't mean he's deciding or she's deciding and gets a green card. What it means is he's giving her a shot at going to court. And that's the way the law was set up. So Sessions now comes in and says no more. No more continuances, no more putting cases on pause so that people can redeem their rights. And it's not a question of putting a case on pause so that months can go by, that maybe something will come up, maybe it won't. Judges have never continued these cases or put the cases on what we call administrative closure unless there's something concrete there to work with. that's been adjudicated or in the process of being adjudicated, a concrete right that is right in place, and all that's blocking it is a procedural decision. Now, from the speeches that they gave at the time he did this, you'd think that the judges are delaying things all over the country and the cases are backlogged because of judges. No, we heard during the luncheon that we have serious backlogs in immigration court. Ironically, in the 2013 immigration bill that passed the Senate, was refused consideration by the House of Representatives, there was money for the immigration courts. People like Sessions himself, when he was a senator from Alabama, and Stephen Miller, his cohort, or his whatever you want to call him, they worked with the House to block this thing after it passed the Senate. And now so it's very ironic that he would stand up and say, "Oh, well, this is about backlog." Yeah, it's about backlog, and if you hadn't blocked it, we might have money for the immigration court so that we have more judges so that the cases move quickly. And it's true. Justice delayed is justice denied. All right, so that's what Sessions was saying. So what has he done concretely in addition to make some procedural moves? How has he cut off the immigration judge's power, which is very dangerous? All right, so removing judges in specific cases. We heard about that. Issuing unilateral decisions already reviewed by non-political judges. So non-political judges, I mean the immigration judges, their career, they're not political. They don't come in with the next administration. That makes significant changes in the immigration law. And I'm going to talk about one of those in specifical, is that a word? Limiting tools for judges to manage their dockets. We talked about that. Attempts to end asylum claims without a hearing. People don't get a hearing. And immigration judge quotas. Putting pressure on these immigration judges to move the cases through, not in the sense that we need efficient and speedy justice, but we need an efficient and speedy deportation assembly line. That's what they're doing. So the one case in particular, which I thought would be worth talking about, is the issue is what have they done with domestic violence and gang violence. That was also mentioned during the lunch talk. You know, the law had developed in asylum over the years so that women fleeing domestic violence were covered as what we call a particular social group. And the law has been developing as it relates to protection from gang violence. So what Sessions does is, in a case called Matter of AB, he tries to change everything. So the standard for what we call when somebody is asking for asylum based on domestic violence or based on gang violence, the rough standard is this. Let me read it to you. An applicant seeking to establish persecution, you have to establish you're being persecuted on account of membership in a particular social group. There are various ways to get asylum. Particular social group is one of the various grounds. The other grounds you may understand would be politics, nationality, etc. One of the other grounds is particular social group, which is very difficult, and the courts have struggled over the years to define. But as it related to women fleeing domestic violence, it's developed so that they were protected. And the cases, they have to demonstrate to get it. The burden of proof, of course, is on the applicant. Has to prove membership in the group, membership in a group, which is composed of members who share a common immutable characteristic, that's something they can't change, is defined with particularity and is socially distinct within the society in question, and that membership in the group is a central reason for the persecution. When the alleged persecutor is somebody unaffiliated with the government, the applicant must also show that her home government is unwilling and unable to protect her. That's a rough statement of what the standard looks like. Now, so Sessions takes this case called Matter of AB. Now, I'm not going to go through the whole case, but I'm going to tell you why it's legally flawed. And what he does is in Matter of AB is he doesn't throw out that rule. He's very kind of sneaky about it. You know that skit they do on Saturday Night Live where that woman plays him. This is what I think about when I think about him writing this. It's kind of sneaky the way he does this. He does not change the existing legal test that I just gave you in Matter of AB. In fact, he reaffirms it. But what he does is he drops a paragraph, which really sort of, if you read the paragraph within the context of the decision, underscores the legal infirmity of what he's doing. Here he writes here, and remember, the way this works is the Attorney General can take a case from the Board of Immigration Appeals and unilaterally rewrite it. So he takes this case on his own motion and he reverses it. Judge, jury, and executioner. Generally, this is Sessions, generally claims by aliens pertaining to domestic violence or gang violence perpetrated by a non-government actors will not qualify for asylum. Generally, right? So he's not excluding all claims, but he's saying generally. While I do not decide that violence inflicted by a non-governmental actor, husband, gang violence, may never serve as the basis for an asylum or withholding application based on membership in a particular social group, in practice, Sessions writes, such claims are unlikely to satisfy the statutory grounds for proving group persecution that the government is unable or unwilling to address. So what's the major flaw here? He doesn't change the standards. The major flaw is that asylum determinations are case by case. What Sessions is doing is deciding a whole battery of cases. He's prejudicing judges and the immigration service that will decide. Generally, they will not get asylum, is what he's saying. Well, who is he to say that? He hasn't looked at each case. This is a case-by-case determination. So it's kind of sneaky here, because it looks like a whole change in the law, and it's not. And then what he does, the other thing that he does, which to me, when I read this decision, was kind of ominous, and I realize this is taking long, but I think it's important if I can find this. All right. At the very end of this decision, he drops a footnote. And this really is something else. He drops a footnote. Now you have to understand, hang on, okay. You have to understand, first of all, how asylum works. You can be substantively eligible for asylum under the law and be denied asylum as a matter of discretion. So it's really a two-part test. You meet all these legal requirements. Yes, you qualify for asylum, you've been persecuted, or you've proved well-founded fear or past persecution. But we're going to deny it because you're a drug dealer. Well, there's other reasons why a drug dealer wouldn't qualify for asylum, but we're going to deny it because you got arrested 10 times for DUI. It's a matter of discretion. So the judge can deny the case even though there's a substantively qualifies. So what Sessions does, and think about the separation of children at the border, and think about the 100% zero tolerance policy where they were prosecuting, Freudian slip, people who came into the country to claim asylum. And as was pointed out absolutely correctly during the luncheon speech, Section 208 of the Immigration and Nationality Act provides that you can apply, it says it clearly, it's plain, you can apply for asylum regardless of how you get here. Whether you get here legally, illegally, however you get here.
I think that's a sign, David.
So anyway, here's what he does in the final footnote, and then I'll be quiet. He says, after all this, he says, by the way, he didn't say by the way, that's me, I threw that in. Footnote 12. Asylum is a discretionary form of removal, and the applicant bears the burden of proof, et cetera, et cetera. Neither the immigration judge nor the board address the issue of discretion regarding the respondent's claim for asylum. Respondent is a non-citizen. And I decline to do so at first blush or whatever, first instance. Nevertheless, I remind all asylum adjudicators that a favorable exercise of discretion is a discrete requirement for the granting of asylum and should not be presumed or glossed over solely because an applicant otherwise meets the burden of proof for asylum eligibility under the INA. Relevant discretionary factors include the circumvention of the orderly refugee procedure, whether the alien passed through or other countries or arrived in the United States from her country, whether orderly refugee procedures were in fact available to help her in any country she passed through, whether she made attempts to seek asylum, et cetera, et cetera. So what he's saying is, look, even if this woman qualifies for asylum after everything I've written here. And even if she's been, beaten to a pulp by her husband and qualifies, she entered illegally, deny it. And when does this come out? This comes out shortly after this whole horrible zero tolerance policy, where they're illegally prosecuting people under the criminal code for coming to the country to legally apply for asylum. So, in a nutshell, that's what's going on. Happy to take any questions.
So I'd like to get at something that I think all three speakers addressed in some fashion or another, and it relates to this affording of authority with great discretion to the executive branch. It sounds like, Josh, you began, sort of saying sort of really, unremarkable principle to say that statutorily the president, and maybe also under Article 2, had the authority to deny entry to all sorts of people. It's INA provisions. And both Alex and David, you spoke of and seem to concede that the Attorney General has this level of authority. This is a discretionary action, so you may disagree with the substantive act. I guess the question then is, sort of what do you fill in, or what then is the limiting principle? Is this just a matter of policy? And want to at least invoke a little bit, and Josh, you alluded to this. Kennedy's swan song concurrence, where he, at least in addressing the president's power, but I think it speaks to Sessions' power here too, says the very fact that an official may have broad discretion free from judicial scrutiny, makes it all the more imperative for him or her to adhere to the Constitution and to its meaning and its promise. Very Kennedyan language there. And then sort of a plea, it would seem, maybe to President Trump. It's an urgent necessity that officials adhere to these constitutional guarantees and mandates in all their actions, even in the sphere of foreign affairs, and I think that would fit within immigration and national security as well. Then I guess the real plea is, an anxious world must know that our government remains committed always to the liberties the Constitution seeks to preserve and protect, so that freedom extends outward and lasts. But I guess to each of you, and Alex, I think you queued this up as well in your question, sort of what are the limiting principles, if you will? What does cabin this discretion, in your view?
I'll start. I think that's a good job by Avi to find a thread between the three of our talks. I have long believed that Congress has given the president far too much discretion, not just in immigration, but in the entire context of the regulatory state. All of a sudden, people are saying, holy cow, the president has too much discretion. Maybe we can have common ground. Maybe we can break bread and find a reason why Congress should reassert its supremacy over the legislative powers. Dare I say, the non-delegation doctrine. Now, I actually think that the statute at issue in the travel ban probably violates the non-delegation doctrine, but for the court's precedent saying he has inherent power. I think much of immigration law probably violates the non-delegation doctrine. Yesterday, Dave and I debated DACA. There's a statute in the INA, I don't remember the number, but it says the secretary shall have discretion to set priorities. If that statute means you can do DACA, that statute violates the non-delegation doctrine. So it doesn't quite work when there's a president you like exercising discretion in a way you appreciate it, and then there's a president who you dislike exercising discretion in a way you don't appreciate. You can't do that. You can't ratchet it back. So I am fully much in favor of Congress reasserting its power, not just in immigration context, but in the entire regulatory context, so that when we have a president like Donald Trump, who I didn't vote for, and I don't particularly like very much, he can't go ahead and do these things where Justice Kennedy says in this swan song, discretion free from scrutiny. Add some scrutiny. Give some teeth. Say you can impose an entry ban for X number of days. That'd be a statute. Before X days, you need congressional authorization, right? That'd be a good idea. Maybe the president shouldn't have this much discretion, but not just immigration. It's across the board, my friends.
Alex?
Please clap.
Clapping for me. I guess in the context of immigration, like as you brought up, there really is no limit, especially in the immigration courts. And Mr. Leopold brought up, he had those 5 points they're all kind of coming true to this day, right? We're seeing these changes happening now. Maybe it's poetic justice of kind of sitting in between you guys. I see both sides of the argument here, right? Going back to the point I brought up before, you have the immigration judges are not independent. So you're essentially, are you further trampling on their independence? Are you kind of creating this rocket docket? I think one of the immigration judges once said in an interview that I'm handling death penalty cases in a traffic court setting.
Wow.
Before the 700 cases per year deadline. Okay, so you have this, but on the other end, again, are cases taking too long? Are people abusing the system? I've taught asylum law here before, and one thing Mr. Leopold probably has seen this when we go to court. There's nothing worse to me. There's like no greater abuse of asylum law when you hear you just know it's frivolously filed. You don't know, but you hear from you sitting in court, you see what the attorneys are filing. Are they abusing the system? Are they just buying their clients' time? This is creating a further backlog. And I think is that what this kind of the current administration, and it's something they bring up during this speech again this week that I brought up earlier. Jeff Sessions says the problem of illegal immigration has only been compounded by issues surrounding the asylum process. The asylum system has been abused for years to the detriment of the rule of law, sound public policy and public safety, and to the detriment of people with just claims. I think, how far is this power extended to? I mean, is it trying to curtail this issue, this kind of asylum gone awry, or immigration court gone awry? Or is it, hey, this is the political kind of flavor of the month we're going to kind of attack the judge's independence and the rights of these immigrants?
And Sessions said that. He didn't offer any proof, by the way.
No.
So, look, there's discretion, no question about it. It's actually important to have discretion in the law. We talked, when Josh and I debated back and forth yesterday, the issue of prosecutorial discretion was really at the center of what we were talking about. The country could not function, law enforcement couldn't function, whether it be in the criminal context or the civil context, without the ability to make decisions based on common sense. And try to think of it as common sense. Unfortunately, right now, we don't see that. Now, the question then becomes, well, okay, would I be saying this if Obama was president? Or, that's really what the question is. What is the limit? Well, I think we've seen the limit here, and the limit is abuse of discretion. And I think matter of AB that I outlined is just one example. Because in matter of AB, this is not about discretion. This is about violating the law. Taking, in a very cagey, smart, Sessions is smart, cagey, smart way, by stating a standard and then standing over that standard and saying, in all cases, this is what should happen. All right, so that to me is a brazen abuse of discretion. And I think that's our limit. And I don't think that we should sit back now and say, well, okay, look, Trump is, this is, whether you like him or don't, whatever. This is Trump, and it'll change under the next president, and that's the way the law is set. No, this administration, in many instances, I really was only prepared to talk about this one instance, is violating the law. Look at look at the sanctuary city case, the Fourth Amendment, the 10th Amendment issues of coercion and things like that. I think the Supreme Court got it plain wrong in the travel ban case. 212F, which was the center of that statute, talks about groups of aliens or class of aliens or whatever. It doesn't, class of aliens has never meant a whole country. And maybe we do need some clarification there. Class of aliens under Obama, every president has used 212F, which is the essence of the travel ban, the president's ability to keep people from coming in. But they've used it in discrete ways. Carter, I think, used it during the Iran problem back in the 70s to bar certain discrete groups of students for a period of time. So that's a whole different debate, which I'm not 100% prepared to talk about right now. What I'm trying to say is the law, I think what's going on is a systematic, in all areas, particularly in immigration, abuse of discretion by this administration, and we have crossed that limit.
Josh, maybe that actually invites somewhat of a response, because that is sort of there was that statutory conflict that at least the court addressed, and that I think the Ninth Circuit had addressed, and then they also addressed the constitutional issue. I guess perhaps you could speak to that, but also, I guess actually the test that it did apply, right, to determine whether President Trump's statements expressing Muslim animus were sufficient to strike it down. The court found it wasn't, and it employed the rational basis test. I mean, maybe you could speak to some of that, because certainly that has been a subject of some criticism as well.
Sure. The issue in Trump against Hawaii was twofold. First, did the travel ban, did the proclamation violate the INA, the Immigration Nationality Act? And second, did the president's actions run afoul of the federal constitution, that is the Establishment Clause? David mentioned the first issue. And there actually are two statutes that are relevant. One statute, Section 1182F, I don't do the INA, I'm the U.S. Code guy, 212F, says that the president has the power to deny entry to classes of aliens, I'm paraphrasing, as he shall deem necessary, if he determines that their entry is detrimental to American interests. Paraphrase, but I think it's close enough. Presidents in the past have denied entry to Cubans. President Reagan did that. Denied entry to class of Iranians. President Carter did that. Whether or not you care much about past practice, the statute itself expresses no limits. It hasn't. There were no allegations that past presidents have transcended these limits. Not one justice in the court actually disagreed with the majority. Despite the fact that all the lower courts focused on the statutes extensively, Justice Sotomayor basically said, I'm not going to look at the statute because the constitutional question is so easy. Okay. But there was really not even an attempt, not even by Justice Breyer, to adopt the statutory argument 212F. The second statute, Section 1151, 1152, I was screwed up like 52, thank you. Section 1152 says that with respect to the issuance of visas, the government cannot discriminate on the basis of nationality. Okay. But the travel ban, as the name suggests, was an entry ban, which focused on entry and not the issuance of visas. And this issue I wrote about fairly early on, and the court adopted the same distinction that I drew, that the prohibition on nationality-based discrimination was not problematic when you have an entry ban. And to the extent that there was a conflict between the two of them, John Roberts didn't write about this. I think he messed this up a bit. But I think you have to resolve it to allow the secretary to make certain exceptions based on where people apply from with respect to visas, so to avoid the conflict with 1182F. And then we have the constitutional question. Did the president violate the Establishment Clause with his bitterly anti-Muslim statements, which are on YouTube? You can find them in 2 seconds. I had argued at some length that the court's domestic Establishment Clause precedents, the Lemon Test, McCreary County, simply don't apply in the foreign policy context. And the court more or less agreed with me on that one. They didn't apply McCreary County. Instead, they applied a case called Mandel versus Kleindienst versus Mandel, which said that so long as a legitimate reason is given, the court won't peek behind the curtain. And the court didn't. The court, considered the statements, but said that that's not enough to render the statute unconstitutional. If this was a run-of-the-mill case where the mayor of a city had made anti-Muslim statements as a candidate and then took some anti-Muslim actions as a mayor, I think the case would have come out a different way. But the president has somewhat unique immunities that other people in the republic don't have. So the travel ban case didn't come as a surprise. The court did more or less what I thought they would do and what I wrote about for 2 years. But again, I think the travel ban case is quite limited. It's in the unique context of entry, and it doesn't apply to aliens already here who have a very different standard. They're protected by the Due Process Clause. It's got Zadivas. I never say the case right. And other cases are along those lines. Thank you.
Can I ask Judge on that?
Please.
I mean, it seems as though the majority opinion does, in some respects, seem to try and have it both ways, or at least rhetorically does, suggesting that it will look back. I mean, it references the terminology, then it suggests it's applying this rational basis test. It invokes, I believe it invokes Romer versus Evans and all the things. And so it has this odd element to it where, its recitation of Trump's statements is fairly sparing in comparison to the dissent. But it does acknowledge these statements were made and then essentially says we're going to apply the rational basis test. Doesn't exactly apply Mandel.
Avi's right. The court does this weird thing where they say, well, our precedents say we apply Mandel, but because the Solicitor General asked us to, we'll go a step further and consider rational basis, which tells me if Mandel is here, rational basis is here, and like strict scrutiny is up here, right? So maybe they went a smidge above Mandel, which is rational basis review, but it led to the same place, led to the same outcome. But they did that only at the assistance of the SG. The court was basically saying we wouldn't do this on our own. And they basically pinned that, saying, look, even Trump wants us to give us this level of review.
Right. Okay. Did you want to add on?
I mean, that may very well, obviously, the court ruled, so the court ruled. That may be an area where we do require a legislative fix. I think that 212F has to be read in context. You know, and if you read it in context, the rest of the statute, even under provision 212, has specific provisions which ban the entry of people who are national security risks. It's very broad. I mean, even reason to believe. So it's still there. It's in the statute, very broad. So I do think that's probably an area that 212F does need to be defined, because I think as we see here, that is an area where the president plainly has too much power, plainly. And just on all different levels, if you look what was done here. And the statute takes care of it anyway.
Yeah, I would add there's I guess another argument that certainly Hawaii made and various amici made as well, which is that 212F was a later provision, later in time, reflecting sort of the more progressive elements of the INA and more in keeping with the Civil Rights Act of 1964 and the like, and so suggesting a more permissive approach that would find this sort of prohibition to be in a fashion that would be unlawfully discriminatory.
You're talking about 203,
No, the
1152.
Yes, yeah. Let me just change gears a little bit. You know, there's obviously a lot of comparison often to within Obama and Trump and deportation and what have you, in the sense that at one time, it seems now long forgotten, and this maybe delves into some of the politics, but President Obama was referred to as the deporter-in-chief. And I think, but I would certainly defer to Alex and David here, in fact, I think Obama's deportation numbers exceeded President Trump's in his couple of years that he's been president. Or certainly his high numbers were higher than any that Trump has ever deported individuals. What in part explains that, if those numbers are correct? And perhaps you could elucidate a little more where there is daylight between the two administrations on deportation.
I'll follow you. We can jump and yell at each other.
So that's true, that the president earned that moniker. President Obama did earn that moniker. I think that, first of all, what's going on there is I think Josh mentioned, the Homeland Security Act requires that the president set enforcement priorities. Section, I think it's 205, something like that, but it requires enforcement priorities, civil immigration enforcement priorities be set. Stated simply, that means who do we deport first? When Obama first came into office, there was, in 2008, the only guidance out there, other than the statute, was what we called the Meissner Memo, which was a loose discussion, a loose guidance to the field on how you prioritize. And I think also from a political standpoint, they were trying to show their bona fides. I'm not saying it's right, I'm not saying it's wrong, so that they could get an immigration bill moved through the House, bona fides on enforcement. And it was a mess, it was awful. Not only the deportations, but deaths in detention. People were dying in detention like they still are today. And the situation was pretty grave. In 2011, and again, you can't discount the fact that the Obama administration was receptive to public outcry. And in 2011, John Morton, who was the director of the Immigration and Customs Enforcement, issued what we call the Morton Memo. And the Morton Memo was guidance, which was more specific than the Meissner Memo, and gave criteria under which people who were encountered or were in immigration proceedings could be given what's called prosecutorial discretion, not deported. I won't go into the whole history, but finally, this keeps going on and it gets more intense, and you can't discount the fact that the dreamers, the young immigrants who came here as children, undocumented, and then grew up and found themselves living in a country that was theirs except for on paper, organized. United We Dream and other groups organized and were very good at pressuring the administration. And that led, I think, in large part to the 2014 memo issued by Jay Johnson, then the Secretary of Homeland Security, which then offered very specific enforcement priority criteria. And after that memo was issued in 2014, the deportations of non-criminals stopped, all but stopped. And if somebody was arrested, people would be released. They were going after people with DUIs and criminals, people who had committed felonies and recidivist misdemeanors, people like that. Actually, they were using, at that point, more common sense. So I think you have Obama starts off as deporter-in-chief. And, there were a lot of things they did in that administration. I think it was mentioned during lunch, locking up families was another one that came later. A lot of things that I disagreed with and that I fought against. The difference is now, you have an administration that came into power almost on day one. Well, day one was travel ban, but on day 2, 3 or 4, they threw out the Obama-era enforcement priorities, and they issued, under the pen of John Kelly, their own new priorities, which basically, if you kind of go through them carefully, they're online, say deport everybody you can get your hands on. That's the only way I can summarize it. And it's not hyperbole. It's what it pretty much says. They list it in terms of we're going to go after criminals, this one, but if you really read all the way through, they define those people, they define the priorities as anybody who's undocumented. So they throw out the priorities, and then they just go after whoever they can get after. And I think as the trends have been since the Trump administration came into power, that they focus predominantly on immigrants of color, predominantly on people who are Hispanic. In Ohio, they have focused tremendously on the Mauritanian West African community. The Atlantic Monthly did a marvelous piece on it, on how they're. So I think the difference is you also now have a white nationalist component to this. And that goes back to who's running these agencies, some of the statements. And there's a sense of cruelty on the ground that you see that I've never seen before. Example was Amr Adi out of Youngstown, Ohio. This was a businessman who had worked the community, brought back downtown Youngstown to a certain degree, et cetera, but he was undocumented. And they did things like, they told us, well, they wanted him to leave on X date. He was ready to leave. They said, you know what, don't. We're going to review the case. He doesn't have to leave. Come in and we'll check things out on January 16th. So he went in to check, as a call-in. They lock him up for no discernible reason. Things like that to show that they have the power. And I think the difference is where the Obama administration, while clearly imperfect, was responsive to outcry, was responsive to, you know what, you're doing this wrong. This is not the right case to be deporting somebody. This is not the right group to be focusing on. This administration gets off on the cruelty. There's no other way to put it. And the only reason that we saw them pull back on the separation, the criminal separation of these children, many of whom will never see their parents again, period. The only reason they had to pull back is because that was they had enormous international pressure. But that's the only time we've seen it happen. So I guess it's the abject cruelty, which is, I think, to feed their base. And that's the only thing I can figure. And the level of it is much different than under Obama, the intensity of it.
Alex?
I think one thing I wanted to add was, in addition to this, is what you're seeing more now than I think we've ever seen in the past are these workforce or workplace raids. You had 2 of the biggest ones in the history of the United States were conducted in Ohio this year. So again, are the target is, I think it is to create this kind of bigger machine for the immigration court system to kind of fill these judges and fill this need of enforcement. But yeah, the workforce raids are, I think, a huge component we didn't see in the Obama administration. And in addition to like you were bringing up before, discretion. I mean, there used to be a time where it was like, hey, I got a good example, single mother going back to Honduras, she has 3 kids, and the prior administration was, listen, stay here, report this every year, we'll figure something out one day, or something's going to come up. Now it's single mom with 3 kids shows up, and she's getting arrested, detained, put into a facility, and deported, and the government, I hear it in court where the prosecutors say, hey, the kids don't have to go anywhere, they're American citizens. While legally true, what mom is going to leave her 3 kids behind if she gets removed from the United States? I think the biggest difference we're seeing between these 2 administrations is, while the prior one did have this preference system, which I think did work, it hurt to a detriment too. But now you're seeing more of there's essentially a no questions asked enforcement, and now you're seeing, and in addition to that, you're seeing workplace enforcement on top of that.
The other thing was here you have a coordinated effort to keep certain people out. Under Obama, you never did. So you have what we just described in terms of on-the-ground lack of discretion and roundups. You have, forget the travel ban. Travel ban you don't even need, because what they're doing in the consulates is various extreme vetting, they call it, over the very extreme protocols they already had. So they're keeping out Muslims, they're keeping out people who have last names. I think we already arrived. They're keeping out undesirable people of color. And so internally, same thing. The sanctuary city attacks. It's all coordinated, and that's an enforcement. This doesn't stop at enforcement. It moves over to business immigration. Substantial what we do at our office is business immigration, and the adjudications are restrictive to the point of nonsense. Huge corporation, show us you have the ability to pay the salary. Really? I mean, so that's what it's a complete and total. And the only way I can, if you want to understand what's going on, go to the webpage of a group called Numbers USA, very extreme restrictionist. Read their mission statement. That's what's going on. It's their mission statement. Zero, what they call a timeout. Zero immigration other than a few people get their spouses in.
I want to make sure we have some time for audience questions. That we have right here. Please.
Larry Herman from Toronto, and I have to confess, as an outsider, a Canadian, I don't know the internal issues that you're describing, and I don't know anything about U.S. immigration law and policy. But when I hear the discussion, and it's particularly the comments about executive discretion, I have a question. And the question is really this: where is the Congress in all of this? And I say that because as a trade lawyer, together with my friend Dick Cunningham from Washington, we've seen the president use discretion to apply extraordinary tariffs under Section 232 of the 1962 Trade Expansion Act. And interestingly, the Congress is now reacting to that, and there's a movement in the Congress, and I don't know, Dick, where it stands now, but many senior senators and congressmen are saying the president has gone too far. He's using discretion far beyond what the statute was intended to allow. So in this case, I hear what you're saying about the use of discretion, discretionary authority, and delegated powers. Is there any pushback from the Congress in this area, as there has been in the trade area?
Congress is absent, and maybe after November we'll see some presence somewhere. But we don't have a Congress that in any way checks this president, period.
Or any president. It's an unfortunate aspect of the modern administrative state, and this is not limited to immigration. I realize that there's a story of the mouse and the elephant, right? If we're looking at part of this huge beast, oh my God, there's immigration, but there's also trade. There's also domestic policy. on Medicaid, on Medicare. There are so many aspects where Congress has abdicated its role, not just immigration. The Supreme Court's abandonment of the non-delegation doctrine to placate FDR in the 1930s was a mistake. If you want to be serious about having Congress reassert its role, it's not just immigration, it's across the board. And I think we'd be in a much better polity if the branch responsible for legislating legislated and didn't just punt and kick the can down the road to an executive who you may or may not agree with.
And I just have to add, specifically to immigration in Congress, the immigration law hasn't changed essentially since April 1st, 1997, with the passage of the last reform. So they've been absent for 21 years, and the system has not been fixed. And it's just a downward spiral.
But I think, you don't have, look, the Homeland Security Committee should be calling Secretary Nielsen before it and investigating exactly why these children were separated with no plan to reunite. That can happen with a Congress that's responsive. On trade, the relevant committees should be calling the relevant officers before. And how are these decisions being made? And investigating. We've had such corruption in this administration with no investigations. You compare that, and let's be clear. We can put in any statute we want, but Congress is political. And the reason that the whole thing is political, the reason that we don't have a Congress that bothers to do its job and check this president is because it's the same party. The Republicans have been completely absent and not checked this president. So we'll see what happens in November.
There was some suggestion that the First Lady's parents might have gotten in through an improper interpretation or perhaps inside politics using the immigration code, but I never heard anything more about that. Was there any truth to that as you understand it?
Yeah, I can address that because here's the issue. And this started in an article in Harper's Magazine back, I think Julia Ioff wrote this piece in Harper's back in spring of 2016. Melania Trump came in as a model. And she says in Harper's Magazine in this original interview that when she first came to the United States, she had to keep going back to Slovenia to re-up on her visa. Well, that makes no sense unless you're coming in on a visitor visa and you have to leave the United States to refresh your authorized period of stay in the United States. Because there's no work visa that requires you to constantly leave every 3 months, at least none that I know of, and we do all work visas in our office, and that law hasn't changed since I was pointed out in many years. So what that suggests is that she was coming in on a visitor visa and modeling, okay? That is legally fraud, if that's in fact what she was doing. I don't know that that's what she's doing, but if she was coming in on a B1, B2 visitor visa, that's the visa designation for a tourist or a commercial, a business visitor. She's making a legal representation upon applying for the visa at the consulate, and the legal representation is that I'm coming in to visit, go to Mount Rushmore, whatever, visit family, or I'm coming in to engage in commercial transactions limited to attending meetings or negotiating a contract or whatever. I'm not coming in to work, and I have a home, what we call a domicile that I have no intention of relinquishing. That is the legal representation she is making and made at that time at the consulate. So when she comes in, she makes that legal representation to the customs officer by showing the visa stamp. You are making that legal representation. If she goes to work at that time within 30 days of arrival, that's presumptively fraud, criminal and civil. All right? So that's where the issue comes up, because that interview made no sense. And so this issue, as I understand it, then was litigated a bit in Politico, and then Washington Post had a piece, and there was never an answer. And the Trump administration, or this Trump campaign at the time, said that they would have a press conference where they would reveal all of the documents. We're still waiting for the press conference. So I don't know. I mean, the point being that if she originally came in with a fraudulent representations, then unless she admitted this fraud at the time that she got her green card, the green card was ill-gotten, and unless she admitted the fraud again at the time that she got her citizenship, then the citizenship is revocable without statute of limitations. Not criminally.
And do her parents lose a derivative?
Yes. Yeah, her parents are now citizens. Becomes more complex at that point. As green cards, they would lose. But her parents are now citizens.
Just to revoke, it gets you material fraud, or I think there's a specific standard to revoke derivative citizenship, right?
The standard of revoking is two types. There's a material misrepresentation or illegal procurement. Illegal procurement, the government will tell you, is to correct a mistake. So if I became a citizen but I didn't have 5 years of residency, technically, then I can... Misrepresentation is where we would go with that. And, there's no statute of limitations on revocation. For the best example of that is the former Clevelander, now deceased Ivan Demjanjuk, who allegedly made misrepresentations about where he worked. He worked at a place called Sobibor. So that's the problem. Whether that ever gets anywhere, I don't know. But it's ironic, right, that the administration, of all the many things they're doing, is attacking citizenship. They now have the Citizenship Task Force that they put together, which supposed to go after people who were under final removal orders and used different names when they got their citizenship and all this sort of thing. Goes back to an Inspector General report back in, I think, 2014 or 2016 or something like that. Ironic that they're putting this pressure on when, their own house may not 100% be in order.
Do any of you care to comment on the enforcement mechanisms of our system, namely ICE and CBE, and is there any real oversight of them and any redress for somebody who feels they have been abused by them?
I'll comment briefly. I think one thing you hear is like the abolish ICE idea, which, like I said, it's not going to happen, right? Any more than the walls are going to be finished on the border, right?
What are you saying?
Yeah, right. They're not going to abolish. I guess the other part of the component about immigration and custom enforcement is something I routinely always say is a lot of these agents, I don't think they wake up in the morning and roll over to their spouse and be like, I'm going to rip this kid away from his dad. I don't think that happens, right? So I think there's generally a job they have to do, and that's what's going on. I think the issue with the enforcement now is there's this blanket of, we find them, we're going to get them, we're putting them in proceedings, we're detaining people, we're not giving people bonds. I mean, before, there's a time where immigration would apprehend somebody, they would review them, do their fingerprints, everything came back clear. Go home, recognizance bond, we'll send you mail, go see the immigration judge. That's no longer in there. You're not going to abolish ICE, right? And part of ICE is investigating child pornography, part of it's investigating human trafficking. Who wants to abandon that agency? On the flip side of the argument, though, is there is no oversight right now. We have this large agency. They all wear all black. They show up, in their unmarked cars, and they do raids. And they're showing up at state courthouses now in Ohio. People are showing up probation appointments. Show up for your probation, meet with a probation officer, and you're getting detained in the hallway. So it's a large kind of arm of enforcement. And same thing at the border. Now the border is enforcing taking your cell phone and reviewing your Twitter account, your Facebook posts, and social media mechanisms to keep you out of the United States.
I don't know that they're just doing their jobs. I mean, yes, I know a lot of agents, and they're good Americans, and they're working hard, and so on, and I respect what they do. But we've got a rogue agency. And the original rhetoric of the administration was, I'm going to unleash ICE. And it's rogue. I mean, the stories, there's just too many anecdotal stories to say, okay, well, that happened once, it's a training issue. And it's a question of dehumanization, viewing people as less than human, viewing quote-unquote aliens as less than human. I think it's a real problem. And, on the abolish ICE, that's not the point. The point is reform whatever it is, so that there is, again, and that goes back to the question on the Congress. If you had a Congress that was doing its job, you'd have the director of ICE hauled before them and ask questions, along with Nielsen. Some of these people, in my opinion, should be looked at by a grand jury, what they're doing with these children. CBP, you mentioned CBP, Customs and Border Protection. That's an agency that really needs to be looked at, even under the best of times, because they, in a lot of ways, operate extra-constitutionally. Alex mentioned cell phones at the border. Before I got here, I was on a telephone call with a client advising said client that when they cross the border, anything that they have on their cell phone, anything that they have on any electronic device, any paper that they have, which we always knew, is readable. That's text messages, WhatsApp messages, Facebook, all of it. It's readable. I've had people call me up because CBP downloaded the text messaging, and because of the text messaging, assumed that the person was coming to the United States for a nefarious reason and sent them back on the next plane. CBP operates with impunity. And at the border, at the port of entry, there is no right to counsel. They take that position for a non-citizen. A citizen or a permanent resident should have right to counsel. But a non-citizen has no real right to counsel. You know, I mean, during the travel ban case, I had a client that was detained. And the only reason we were able to get her back here was because she had her cell phone, and I was texting her, and I was able to text her, tell them you have a lawyer, tell them you have a lawyer, which she did. And because of that, the federal court included her in the first travel ban case in New York. So, you know, that's not how we're supposed to be operating in this country. So there's a lot of work that needs to be done in that area.
Sorry. Hi. David, I want to maybe just push back a little bit, and I apologize if I'm misquoting you, but you seem to give the implication that we've never had an administration push back against a specific group the way we've seen the Trump administration push back against Muslim entry, Muslim refugees, etc. And I mean, that's just not true, right? We had even the Council of Foreign Relations saying under the Obama administrations that, like, you know, Syrian Christians, Iraqi Chaldean Christians, an acknowledged persecuted group that qualified for refugee status, there was a de facto bar in the State Department's application of their refugee claims. So, I mean, again, if this is all discretion, I'm kind of some of what we talked about yesterday evening. But I mean, if this is all discretionary, this is just the administration, rightly or wrongly, exercising its discretion the same way the State Department under the, during the Obama administration implemented this de facto bar against persecuted Christians in the Middle East.
Well, look, I mean, I think if you put it all together, what you have is a scheme that's really targeting people of color. I'm sorry, and we've never seen anything like this before, ever. Yes, there have been groups that have been, after 9/11, come on. Muslims and Arabs were targeted, of course, in the wake of 9/11, and we fought that back. But, now you see it at all ends. And I don't think when the president himself refers to, I don't think we can just say, oh, that's just the president's rhetoric, shithole countries, or I like Norwegians, or whatever the hell he says. Come on. I mean, let's be real. That's who's being targeted. When you look at a community like the West Africans in Columbus, who are all of a sudden under siege by ICE, and you look at, how many? We have a lot of undocumented Canadians in this country, and I'm not joking. When was the last time you heard of a roundup or a targeting? Not that should have. I'm not trying to give anyone any ideas, but so I mean, let's be clear. Let's stand back and look at what's going on. Look at the enormous effort. Look what they did to those children. Do you think that they would be separating European kids from their parents and sending them off like they did with no plan to reunite? Yes, I'm speculating, of course, but I think there's a lot of circumstantial evidence which suggests that the trends that I and others are seeing are pretty correct.
I actually was going to raise a question, actually. I didn't have my hand up, but then I saw the microphone coming, so I figured I might as well. I just wanted to ask a question regarding the legality of sanctuary cities. It's kind of a meme that we've seen be really perpetrated by the right in the past couple years. I know, Mr. Leopold, I read an article actually you wrote in Medium about the topic. And so I was just wondering where kind of the thought is in the legality of sanctuary cities and where we stand as far as that whole aspect of the immigration debate goes.
We can make sure that, Josh, I don't know if you want to speak to this as well.
Yeah. How much time do I have left?
We have just about under 10 minutes.
Okay, I can do it in much less than that. The issue with sanctuary cities concerns a few different aspects. There's no one definition of a sanctuary city. That's not a term. It's broadly used to refer to jurisdictions that decline to provide varying levels of assistance with the federal government with respect to immigration. Now, there's a basic principle in our dual sovereignty. Congress cannot enact laws that commandeer or force states to take certain actions. If Congress wants to prosecute, say, marijuana offenses, they can send drug officials to a jurisdiction and arrest people for smoking dope. They cannot require local officials to prosecute drug offenses. Likewise, if Congress wants to deport people and round people up, they can send ICE agents to your jurisdiction. Congress cannot force local officials to perform immigration functions. But these issues collide in one specific context, what's called a detainer. Generally, if the police want to arrest someone or hold someone, they need to get what's called a warrant, which requires going before a neutral magistrate and demonstrating there's probable cause to believe that a crime has been committed. But immigration is a civil and not a criminal offense. Therefore, under our laws, you don't need a warrant to detain someone. Rather, the immigration official can issue what's called a detainer that says, we want this person. What happens if a state or a city has a person in their custody who's not here legally and a detainer is issued? Does the federal government have the power to order the state prison to hold this person perhaps longer than their sentence to allow ICE to pick them up? The flip side is the state police doesn't tell the government when this person is being released, and the ICE has to pick them up in a home situation which might be more dangerous. So a number of states have said we will not share information with the federal government about when we're releasing individuals, and we will not honor detainers. There's a statute, Section 1373, which I think was poorly drafted, and it basically says that states cannot, the double negatives can get confusing, states cannot refuse to share information about a person's immigration status with the feds. Now, if you read the statute literally, it doesn't really do anything because no one's really asking what's the person's immigration status. They want to know where is this person, when's he being released. So the statute that Congress enacted is pretty much useless. And I think it probably doesn't do much to help the Sessions Justice Department in their pursuit. But what actually does matter is funding. And there have been efforts by the Sessions Justice Department to withhold certain amounts of funding from sanctuary cities. Now, could Congress withhold this funding? Yeah, they could. Can the AG do it by himself? I think that's a closer call. It's unclear exactly what kind of discretion, the magic word, the D word, right? What kind of discretion the AG has to withhold this funding. I'm not done yet. But now we get to California. California enacted a number of so-called sanctuary measures. And I think that they're mostly fine, except for one measure, which actually makes it a criminal offense for local businesses to comply with certain types of immigration raids. I think that perhaps crosses the line. Maybe, it's iffy. There's another provision which allows state officials to inspect federal detention facilities. Unclear exactly what that results in, but if you have a state official trying to shut down a federal immigration facility or impose punitive burdens on them, that may run afoul of what's called the Intergovernmental Immunity Doctrine. Go back and read McCulloch v. Maryland and Gibbons v. Ogden. State institutions cannot cripple federal institutions. So I think the general premise that states can't be commandeered to implement federal immigration law, that's fine. I don't think there's a problem with that. Does the AG have the power to withhold the funding? Depends on the statute, but I think Congress could pass that sort of statute if they wanted to. Can California actively frustrate federal law? I think it's a much closer call. I think they might actually lose that one. I'll stop.
David or Alex, you have anything to add to that?
I have no comment on this. I'm sure these two they're biting at the apple to get to it.
Just briefly, I think what it boils down to is The states, and even in the state of Ohio, there's no duty to collaborate with immigration and customs enforcement. I mean, and it's pretty clear that Congress intended it to be that way. There is a specific provision, 287G, which provides for memorandum of understanding if a state wants to use its agents to collaborate or to enforce immigration laws. It's limited to state participation in immigration enforcement is limited to when the officer, at least in this state, when the officer actually witnesses or has probable cause to believe that there's a criminal offense that's occurred, immigration, related. But I think at bottom, what we're talking about is smart policing. Sanctuary is kind of an odd word to use because there's no sanctuary. Immigration and customs enforcement can operate in any of these California towns, can operate in San Francisco, any of these towns that are always touted as these Nancy Pelosi sanctuary cities. Immigration is there. What goes on, and that's on that, the big argument is, well, the law mandates they share the information, and the statute, I agree, is poorly written, but that law does not require them in any way, shape, or form to ask for the information. So the rationale is that, if we devote our resources to immigration, a couple of things happen. The communities become much more worried about their local police. If I go to the police, if somebody's raped, is she going to go to the police because she's undocumented? Because the police are cooperating with ICE, they're going to turn her in. And we've seen that happen, actually. ICE goes after people who have been abused, to your question. And so there's a bunch of policy reasons why, in favor of local law enforcement, mainly community trust, focusing on local law enforcement. It's a thorny issue that way. The administration has really politicized it, obviously, but there is no legal duty for a local municipality or state to participate in immigration enforcement, which makes sense from a policy perspective because, if you haven't figured it out, this stuff's complicated and the law is complicated. And just because somebody is here without documents doesn't mean they don't have the right to be here. A woman could be in the country without documents and be eligible for Violence Against Women Act protection or something like that.
Well, with that, please join me in thanking our panelists. We have our last break, 15 minutes, and then we will have the use of force and rogue regimes panel.